सेकंड वाला यहाँ पे वो स्पीच दे रहे हैं। ठीक है, तुम्हें मेल की। हाँ, मैं वही बोल रही हूँ, कॉपी वाला हटा देती हूँ। ठीक है, ये हटा दो। ठीक है, इसके बाद MDI वाला पोस्ट कर दीजिए। मतलब इसके बाद ना ये वाला ऐड कर दीजिए इसके साथ। ठीक है, फिर
So now we are all there. Just wait for two more minutes and then we start.
फिर ये सब पोस्ट जैसा रहता है रहने दीजिए। ब्रिक्स को जैसे हमने ब्लू पिरोमिड को एंड में रखा ना फरवरी का, ब्रिक्स को वैसे रखिए। कॉन्बिनेशन ठीक है। इसमें ना बोले तो 3 महीने का है ना, प्रॉब्लम हो गई। पहले अभी 3 फोटो हटा। हाँ, ये भी बताइए कंट्रोल को कर दो। बस जब कोई पे बोला जाए ना
पहले बोला था करने के
ठीक है। ये हटा दो। ठीक है, इसके बाद MDI वाला पोस्ट कर दीजिए। मतलब इसके बाद ना ये वाला ऐड कर दीजिए इसके साथ। ठीक है, फिर
So now we are all there. Just wait for two more minutes and then we start.
Hello.
Hello.
I would request everyone to keep their
muted.
ब्रिक्स को जैसे हमने ब्लू पिरोमिड को एंड में रखा ना फरवरी का, ब्रिक्स को
Excuse me, I would request everyone to get their microphone muted.
इसमें ना बोले तो 3 महीने का है ना, प्रॉब्लम हो गई। पहले अभी 3 फोटो हटा। हाँ, ये भी बताइए कंट्रोल को कर दो। बस
Okay, so without further ado, I would request somebody is unmuted. Would request you to please mute your. Okay, good morning, everyone. Distinguished guests, colleagues. Who? Can you just
Let's ask the admin to keep anybody who
Hello,
unmutes
Sushri
themselves to
Mishra.
mute them.
Please mute yourself.
Jyoti, please try. If you are the admin, please mute them if they unmute themselves.
Yes.
Or else ask Arun to do that.
Hello.
I would request everyone to keep their
muted. Excuse me, I would request everyone to get their microphone muted.
Sudhir, I think now we are good to go.
Not yet. Somesh, can you mute everyone, please?
Yes, sir.
Yeah, perfect. Okay. So, without further ado, I would request somebody is unmuted. Would request you to please mute your. Okay. Good morning, everyone. So hopefully now I'm audible to everyone, and it is muted. Yes. Good morning once again. Good morning, all the distinguished guests who have spared their time and in celebrating with BCKIC the World Intellectual Property Day. Guests, colleagues, and friends, very good morning to you all. It is my privilege to welcome you all to the Fireside Chat organized by BCKIC Foundation in observance of World Intellectual Property Day, a day dedicated to recognizing the crucial role that intellectual property plays in fostering innovation, creativity, and economic progress. This day underscores the growing importance of protecting ideas and inventions as we navigate an increasingly knowledge-driven world. Intellectual property is not just a legal framework. It is a catalyst for empowering creators, entrepreneurs, and business to transform innovation into impact. At BCKIC Foundation, we are committed to nurturing a vibrant ecosystem where innovation thrives and intellectual assets are both valued and protected. This conversation is a part of our broader efforts to engage stakeholders across academia, industry, government, and startup community on the evolving landscapes of IP rights. Today's session will feature insightful dialogue from thought leaders and practitioners who bring a wealth of experience and forward perspective on how IP can drive inclusive, sustainable development. We hope this discussion will spark reflection, foster new connection, and inspire action as we continue to build a future shaped by knowledge, innovation, and responsible IP stewardship. Thank you for joining us today. We look forward to an engaging and thought-provoking exchange. Now, coming down to our expert panelists, I would like to introduce you to our experts profile today, initiating with Dr. Vinita Jindal. Ma'am is with an expertise of more than 15 years in intellectual property and technology management and serving as Deputy General Manager and Head of Intellectual Property at BIRAC. She is a registered patent attorney with Indian Patent Office and a certified technology transfer professional. She has been instrumental in facilitating technology transfer across diverse sectors, advising on patent filing, strategy, and IP protection across multiple jurisdictions. Her role also encompasses overseeing technology licensing, acquisition, and enabling innovation-driven collaborations across academia, industry, and startup. Next is Dr. Nirvashini Sheetal. She is live from South Africa. A distinguished innovation strategist, Dr. Nirvashini brings an over 20 years of experience across South Africa's national innovation system. She holds a PhD in system thinking with a focus on commercialization of public research, an MBA specializing in virtual business incubation, and a Master of Science in Geography and Environmental Sciences. Currently heading the Technology Transfer Office at the Council of Scientific and Industrial Research, CSIR, Africa's largest research and technology organization. Dr. Sheetal plays a pivotal role in driving technology commercialization, fostering public-private partnership, and strengthening the innovation ecosystem across continent. Next, I would like to introduce Ms. Sudha Samiksha. Ms. Sudha Samiksha is currently serving as senior legal counsel at Pratilipi, a leading digital storytelling platform in India, a gold medalist from Karnataka State Law University, and a top-ranking LLM graduate in intellectual property and business law from NLIU Bhopal. She brings strong academic credentials to her role. She began her legal journey at a boutique IP firm, later contributing to Shimaru Entertainment Limited, where she handled trademark searches, filing examination, responses, oppositions, and drafted and vetted IP content licensing and acquisitions agreement. At Pratilipi, she continues to provide strategic legal oversight in IP, content licensing, and digital media law, playing a key role in protecting and enabling creative expression in digital space. Next, we have with us Dr. Aurobinda Panda. Aurobinda Panda is a founder and managing partner of Lex Protector LLP, an international law firm specializing in intellectual property rights. With a robust background in international trademark and patent consulting, IP valuation, he has been instrumental in establishing Lex Protector as a global player in IP services. Under his leadership, the firm has expanded its presence across multiple countries, comprehensive IP solutions to a diverse clientele. Aurobinda's academic credentials include a postgraduate business management from XLRI Jamshedpur and a specialization in intellectual property law from KIT University. His entrepreneurial journey began during his college years, culminating in an initial launch of Lex Protector in 2013. I welcome you here, sir. Dr. Pawan Kumar, he is next of our panelists. Dr. Pawan Kumar is currently serving as Senior Scientist in Department of R&D Planning and Business Development at CSIR Institute of Mineral and Material Technology, Bhubaneswar. He holds a PhD in chemistry from Osmania University, Hyderabad, with his doctoral work conducted at CSIR IICT as a CSIR JRF SRF Fellow. A university topper and a gold medalist in MSc Organic Chemistry from Osmania University, he also holds a PG diploma in patent law from Nalsar, Hyderabad, along with several certifications from WIPO. Dr. Kumar brings diverse experience in research and intellectual property, having worked with Dolcera IP firm, NRDC New Delhi, and Inspire faculty and assistant professor at CSIR. He was also a visiting professor at North Dakota State University. Prior to joining CSIR IMMT, he served as assistant professor at TGAC, Puducherry. With this, I conclude the introduction of all our panelists for the event, and I am sure they represent all the diverse arena of IP and intellectual property, including the current theme of this year, entertainment and copyrights. So I would start this discussion with Dr. Vinita ma'am, and my first question to you, ma'am, would be to shed a light on the current, ecosystem of intellectual property in India, because we as Indians are celebrating our intellectual property strides also, how our knowledge economy has grown leaps and bounds, and your experience will be pivotal because BIREC is one of the spearheading organizations in this space, in startups specifically. Ma'am, to you, please.
Thank you, BCKIC team and Mr. Sudhi for the brief introduction. So yeah, first of all, wishing you all a very World IP Day, and this time the theme is like feel the beat of the IP. So when we say feel the beat of the IP, so not only we are talking about the copyright, trademark, patent, the whole what exactly has been done by different ways of IP. So we have to feel that part of the IP protection and the IP management. So coming to the question, when we are talking about how India has come to a stage where we are we have grown enormously in the past, everybody knows about it in terms of the innovation index, and when we talk about the WIPO innovation index and the WIPO reports, so in terms of the patent filing, trademark filing, and the way we are protecting our startups are growing and recognizing the protecting the IP. Whatever, I mean, the kind of innovation they are doing in all the sectors, not only in the biotech space, but in other sectors also. They have the awareness of how their creativity or the innovative work should be protected by any means or any forms of the IP. So what we have seen, because in BIREC we promote the biotech innovation ecosystem. And when we talk about the biotech innovation ecosystem, we talk about these innovations majorly can be protected by way of the patent. So patent is, yes, initially they were focusing more and more on the patent part, how innovation can be protected. But at the time, they move forward in their innovation cycle or in their innovation development. So they realize the importance of protecting the brand name, the product name, and the domain name also. So they have so patent to trademark to trade secret or to the copyright. So they have the awareness. So this thing we have enormously seen the changes in the startups, how they are realizing the importance of IP protection. So we have grown enormously, tremendously in terms of the patent filing. And as a system, if we see the Indian Patent Office, the work they have done in terms of examining the patent applications, not only patent but other trademark and other applications also. So we have seen a number of patents have been granted. in the past, couple of years. So this number has grown tremendously. So when we have the way they are examining, and they are increasing the speed of examining and granting the patent, this is actually becoming a beneficial for the startup companies, for the innovators, and also to the academic institutions, because they would like to transfer, they would like to have a patent in hand, so that they can talk to the various investors if they want to move forward and they want to practice outside India also. So overall, we have come a long way ahead in terms of managing the IP, protecting the IP, realizing the importance of the IP. Though yes, there are few areas, as well as few we have seen, because like in BIREC, if we talk about, so we have seen a lot of startups are still in initial stage, they are not very much aware of IP protection. So with the help of the BIREC and with the help of our partners, we encourage them to learn about the IP, to make them aware about the IP. So that is also happening, so that we can make them aware and we sensitize them, and of course they think about IP protection and IP filing. So I'll stop here, and
Thank you, ma'am, for shedding light. Yes, we have indeed, shaped and with leaps and bounds, we have, excelled in this segment, and specifically in the startup arena. As you rightly mentioned, awareness is still the key to reach a wider audience, because India is a very vast geography, and reaching to each and every corner would be very important. Now, coming to Nirvashini, ma'am. I am sure with a fresh perspective of South African ecosystem of IP and innovation, and being rooted through the Indian aspects as well, what would be your key take in terms of what is the ecosystem in South Africa, and what you have seen or observed during last few years, the transition in Indian innovation landscape, and especially with perspective of intellectual property?
Hi, Sudhir. Yes, thank you. So our system is not that much different in terms of the startup space. We do have quite a significant startup space, but it's limited in the same way. We have quite a high failure rate. I mean, that happens with, I think, in virtually every country. And there's also, when you look at it from the intellectual property perspective, there is still a limited understanding of intellectual property. Most understanding tends to be centered around the patent space, with a lower understanding that intellectual property extends through quite a vast spectrum, not only patents, I mean, copyrights, trademarks, even things like know-how, and making the effort not to disclose early. Often startups want to just get started. They just want to hit the ground running. They want to get into the market, and the IP strategy is left as an afterthought. So there tends to be a serious limitation in terms of putting an IP strategy together very early in the startup journey. But having said that, the system has also been evolving for quite a number of years. We've had significant changes in our legislation. So now we have a very robust legislation in terms of how we protect our intellectual property. And it's continuing to advance in that space. We also have several institutions in the country, both private as well as public, that do make an effort to support small businesses, to support startups and so on in various ways, to get through multiple aspects of ensuring sustainability in the space, one of them being IP protection. So you know that we've got the CIPC, which is basically our national patent office, if you like. But in that space, we're also still transforming, because we're not an examining office. So the country is currently transitioning towards becoming an examining office. We're currently training patent examiners and so on. So, there are certain parallels to be drawn between the Indian innovation ecosystem and the South African innovation ecosystem, in the sense that both are fairly large. Obviously, ours is nowhere as near as large as yours, But because both have come from a developing country status or in developing country status, the challenges tend to be very similar, and the attempts to address the challenges are also very similar. I'll leave it at that for now, Sudhir.
Thank you, ma'am. Indeed, we both have, higher failure rates, but the strides are very, very promising for both the countries. And we have seen quite a good trend from Indian startups and getting their patents filed in South Africa for the quicker conversion of their and safeguard of their technologies. So indeed, it will be a promising future for both the economies put together. Coming to you, Dr. Pawan sir, you are from a pioneer industrial academia cohort, and your inputs on, how you observe in IP awareness and management between academic researcher and entrepreneurs differently. And is there a gap which needs to be bridged in this scenario? Because, we have too many pioneering institutions, but the conversion of patents from these institutions somehow and conversion into a viable business model out of it also is pretty slow compared to many developed economies. And we wish your take on that current scenario.
So, right, a very good morning, and I could see many of my fellow panelists whom I know each other. Arbindaji, I think we met 2 years ago when you conducted one session at this STPI, and many others. Jindal Vinita is my good friend. Yes, like you pointed out, when we talk about awareness, I believe awareness is the first thing that we need to do at a larger scale. It is because of lack of awareness, most of our struggles are still there and they will persist for some more time at least. Though we talk about improving with respect to IP practices, I find that improvement is not really an effective improvement. Hardly institutions are having a very organized IP culture in their regular activities. Even if I have to say, today being World IP Day, I could find many institutions celebrating this occasion. Only on this day they'll talk about IP and then they'll forget, they'll wait until 2026. Of course, KIT is an exception. And even to my knowledge, Bhubaneswar ecosystem is one of those exceptions. But at last, this is what is happening. And if you talk about research institutions like CSR, ICR, ICMR, majority of the research personnel working there, maybe scientists, maybe researchers, or even the project students, they hardly have a proper understanding on what is called IPR. They might be having awareness is different, understanding is different. Unless they have proper understanding, they cannot think towards contributing effectively. So what we practice is, first step is awareness. That itself is lacking largely in our cultures. Once you have a proper awareness, then there is a possibility of going for understanding. Understanding needs a deeper level of inputs. Once you get proper understanding, then there is a possibility of researchers or academicians putting efforts towards some constructive contributions. So this understanding part hardly people realize. With having awareness, they say that yes, we have good awareness on IP, we want to take IP, we want to have IP. But what exactly is IP? What are the different kinds of IPR? From your research work, particularly at which stage you need to think about IP, hardly they know. Many people come to me from my institution and from other institutions. After completing their work, they come across IP and someone would have referred, they come to me, Pawanji, we want to take a patent on this. By that time, they don't realize that many similar works have already been filed or published somewhere here and there. So therefore, the first step to improve this IP culture is locating our inventions before we start experimentation. I think all the IP experts present here, they do agree with this. Because whenever you plan a research work, before you start experimentation, you should be confident enough that yes, this research work has a decent scope for IP. Locating IP is more important. And for patents, locating a patentable space is even more important for researcher. If it is done, 50% of the job is over there. And while practicing the research, while continuing their experimentation, they should keep a parallel track of the progress happening around. Once they reach to a final conclusion, again, they should have a similar kind of confidence what they had earlier. If that is there, yes, the problem they worked is a proper problem to reach to a final conclusion. Otherwise, they have the flexibility to change. This systematic approach is not taking place. The reason is hardly people are having a proper awareness and understanding. But everyone is looking for the credit of IP. And because of that credit part, people want to contribute towards IPs. I see because in NIRF rankings, NAC gradings, IP is there in the forms. To fill those forms, people are looking for IP. Not that we should definitely contribute to something new. Maybe this kind of practice need to be reoriented. So these are my inputs on this.
Rightly said, sir. And you have hit the, nerve point of what our academic institutions and, the entire ecosystem right now is doing with perspective to IP. But indeed, there are few greener shoots as well. And I see Arvind sir smiling for that, basically. And we all agree that this is a learning curve which our country particularly is taking in this space. And definitely we have come up in much better way. We do have startups which have started leveraging IP as an important aspect of their progress as well, and translating it into economic progress. Coming to you, Sudha ma'am, we are talking of patents in perspective of startup and innovation ecosystem, and you bring in a very fresh perspective of other form of intellectual properties like copyrights and other, where the awareness is still very, very minimal, even I would say for the trademarks, basically, which is a very simple, first stage of intellectual property, which a startup or innovation or innovator needs to safeguard. What is your take and, experience in this 20 years? Is it shifting towards better awareness, or what needs to be, focused, let's say, for an institution like BCKIC to bring in that aspect of taking, in addition to patent, other forms of intellectual property to the mainstream, basically? Ma'am.
Yes, I completely agree with this fact that awareness with respect to intellectual property rights, not only in terms of protection of these rights, but also in terms of enforcement, is quite limited. So patents is a major aspect, I mean, is a major area of practice, that I agree. But when it comes to copyright laws and when it comes to trademark laws, what happens is a lot of creators in the first place do not have this understanding of what are their basic rights in a content and how those rights can be protected and monetized. That awareness can be taken up by organizations like BCKIC, so that creators, authors, original IP owners are aware about what is the commercial element in their creation, right? And coming to startup founders, what I completely agree is registration of a particular intellectual property like a trademark or say like a copyright. Even though all these registrations might not be mandatory under law, they do give an edge if it is registered, right? So in such cases for startups, what I believe is such early registration is immensely critical, because we need to look at all these IPs as intangible assets, and they can be considered as a foundation stone of any of growth of any organization, and it does give an it does give a competitive advantage and will help a startup to have that kind of valuation and exit in the future. So I think a lot of expertise and guidance and awareness IP education can be brought about by institutions and organizations like BCKIC, and that should be commercialization of IP should be the main goal, because it just adds a lot of importance to a portfolio of a particular startup, and it is lucrative for investors. Yeah, that is all I have to say for this.
Thank you very much, ma'am. And indeed, in addition to patent copyrights, and now we have seen a lot of even cases coming in India wherein we have further awareness and even lawsuits getting in for copyrights and other infringements. So definitely we are getting more aware and creators are getting more aware, and further needs to be done in terms of generating more awareness towards what individual level, creator level safeguards can be put in perspective. Thank you, ma'am. Now coming to Aurobindo sir, your experience internationally with patent filing and different forms of consulting in IP ecosystem. For you, I have a more generic. This thing is how IP can be used strategically, and you have seen very many cases, and I go through your newsletters to understand that sustainability and using or leveraging IP as strategic aspect into sustainable development. And I have seen quite a few examples which you keep on sharing it with us through your newsletters. And in growth and investment segment, how do you pitch this IP as a leverage for Indian innovation ecosystem? And your experience from different countries, cases, if one or two you can, highlight in this regards.
Yes. So a very warm welcome everyone for today's World IP Day, and thanks Sudhir for the question. So with regard to intellectual property, when it comes to international front, especially in Europe, especially in US, it's they are very aware of. Even if we say that okay, maybe this is not possible, they said that you don't worry about it. Go ahead and file it. You don't worry about the money. You don't worry about the outcome of it. Let's file it. If there are 2 trademarks, they will file 4 trademarks, saying that why don't you file? Whereas in India, if we say that okay, there is 2 wordmark and trademark is possible, they'll say that okay, can't we put 1 trademark and file both of them? And 90% of the trademarks that we file, maybe the lawyers that we file, do not have a date, user date. And India do not need a user date to claim the trademark. And they file it as used, like proposed to use. Maybe the trademark has been used for 10 years, but they don't even bother to ask this question, whether it is been used or I should file a trademark without use. So the awareness of international IP, the international with regard to US and the developed countries and India is a lot more gap. That's why we see the filings are having a lot more gap. Also in terms of trademark, in terms of patents. When it comes to like the world IP trademark and patents, we are somewhere around 5% of the world IP filed around the world, right? So below that, I would say. Whereas China is now overtaking like 60-70% of the filings. Just to give you an example, let's say we talk about WhatsApp. Okay, so when I send you a message on WhatsApp, I get a tick. Okay, and when you get the message, it becomes double tick. When you read the message, it becomes a blue tick. So this itself is a patent. Okay, that's right. This is how patents have been created. The flow of the communication which happen online, so that the easy knowing that the delivery and the receipt of it. Okay, and similarly that there are 18-20 patents when Facebook acquired WhatsApp at some point of time with a huge $1 billion deal, right? So that's where IPs are created. In India, I would say the creation of IP is done. But when we create, we are not aware that it can be protected. See, I would say more IPs in, there are more IPs created in a garage or a mechanics out there who is, or a factory workers who is working in the factory rather than an academia who is doing PhD. Okay. They might be doing it for credit, as Pawan rightly pointed out, but there are some Jugaad patents which has a potential of changing how we see IP, right? At the same point of time, when it comes to the protection part, so we in Lex, at least in Lex, we go through the 4 pillars of how we see intellectual properties: create, protect, utilize, and maximize. So creation is a phase where you create the intellectual property. You are in the stage of creation where you need the maximum support to identify, to find out what is the best to go for the protection part. Then once you go for the protection part, you try to utilize yourself, or you try to give it in terms of licensing and make it public. And then once it is public, you will find out there are more patents or more trademarks which is possible, more forms of IP which is possible, change of forms of IP which is possible, and you go ahead and protect them and go for the maximization of it. In terms of AI now coming into, there's a lot more space which we are missing out somehow, where China has taken a lot more and US has already taken in AI ML a lot more patents, which we have drafted file. Just in India, it's 3 years back, we have a judgment, or 4 years back, we have a judgment where we define what is a software patent. Okay, and then we are accepting now the software patents. So even the law is there for 20 years, no one interpreted it. And we thought that, okay, copyright is not a subject matter of patent. We'll copyright, we'll only copyright, we'll not patent it, the software patents, and then we are losing up. We have lost 20 years of protection, I would say. So in that way, the AI is the next thing which we need to have some early case laws, or maybe early's detection of how we can protect, or maybe one more upcoming law on AI robotics. So those things need to be in our mainstream, and the protection of the legal framework or the policies also need to be framed also. Yeah.
Thank you, sir. Indeed, the speed with which this innovation ecosystem should be nurtured with government perspective, as well as we content creators or innovator, is very important in the current global scenario, wherein quick conversion of intellectual and safeguarding all these technologies, and we have seen with DeepSeek and Open AI, and it has played out well for the entire world to see how quick conversions can disrupt the entire market. Thank you very much, sir. Vinita ma'am, with your immense experience.
Before we move forward, can I add one more point? What
Yes,
Dr. Arvindo and Dr. Pawan talked about. So while we are talking about the IP awareness, so of course, when we talk about the IP awareness, we, everybody, I mean, all the organization try to, aware or sensitize the startups, innovators, academic institutions on different parts of the IP. So what we have seen, I mean, when we talk about locating a prior art, how to locate a prior art. So we talk about the prior art searching or the patent searches. So they are not aware of the patent analytic part. So what we have started doing, we have started, keeping one session on how to do a patent search, so that at least, to make them familiar how the patent look like, how you can search on your own before, you go to the law firm or any patent agent to do a patentability search for you. At least they can have a feel of how to conduct a patent search. So locating a prior art, and to make them understand, that is also a, very, it's a good step to have as part of the IP awareness session. So yeah, so slowly and slowly, I think everybody will be including the prior art search, how to conduct a prior art search as part of the IP awareness program. And that is very helpful for the innovators, because at least they can do some, prior art search, though they might not be having access to the paid databases, but of course they can do a preliminary search on the freely available patent databases.
That indeed is one of the major thirst areas BCKIC Foundation we are doing. We have been since last 1 year sensitizing entire ecosystem in Eastern India, specifically on searches and individual drafting at the research level. So doing the prior art, seeing how they can draft the claims. If refinement is required, we intervene and we help them, but we are not helping them in drafting it off. We are telling them, you write, you draw your IDF, you bring your innovation to us in your interpreted format, and we will see how it can be made legally viable. And Aurobindo sir is one of the key mentors in that space, which we have been leveraging. Open patent databases like Google Patents, our national patent portal, as well as SpaceNet or eSpaceNet and all. We are, trying to deliver that throughout year. We are doing these sessions, and Smrita is missing here. She is spearheading this entire, vertical here at BCKIC Foundation in association with all our colleagues from the BCKIC Foundation. Now coming to you, ma'am, biotech space, and specifically it has been key lever for the development of Indian innovation ecosystem. How do you see that this biotech IP ecosystem is going to help again further nourish and nurture the entire intellectual ecosystem in India? What is your take for the next 5 years with perspective to BIRAC? How you are shaping this for the startups, early innovators, as well as ideation creators, like very early ideation creators? So your take on that, ma'am, please.
So if I go back, little back when we started BIRAC, so there were startups started, coming to us for funding. So that time, so what changes, we have seen so far in last 10, 12 years. So initially, whatever the proposals we were getting from these startups, we were not able to locate any patent. But nowadays, what happens, and that is all about the awareness and to protect their, idea or the proposal which they are submitting to different funding agencies. So now they have IP already in place when they write proposal to any funding organization, and so that they have an understanding, like if they have protected their idea or the innovation while writing a proposal, so this kind of sensitization is there in the startup, and I think it will continue. They are not, shying, like in terms of if they have to, proceed further with different, patent filing, they can do it. And they agree, like whatever patent they have filed, this would be a kind of preliminary patent where they protect it. But they are now, because as soon as they receive the funding, they improve their, design or the innovation, because that time they might not have done the research component. So based on the outcome of the research, they improvise on the existing innovation, and then they further, think about filing a patent application. So for the biotech startup, and if they are funded by the BIRAC, what we have done, we have created a program which we call it as BIRAC Path Program, under which what we do, we help them on the financial part, filing a patent application, not only in India, and it starts with the provisional patent filing. So as soon as you come to us for the provisional patent filing, we connect them with one of the law firm, so that they can guide them. Of course, patent drafting will be done by the empaneled law firm, but the startups will be connected through us with the law firm, so that technically they can make them understand what is the innovation, and they can draft the patent accordingly. So we have funded, around, not many, but because our scrutiny is quite strict in that way, so we have recommended so far very low number, but yes, around 50 startups have been funded under this program. So provisional filing and then complete filing, of course, it's all committee driven again. So startup will get a chance to defend, their case, and if they are looking for the national phase filing also, so they present their case to the committee, and we also support for the national phase filing. And maximum support we have provided for the national phase filing, because all these startups comes with the provisional or the complete patent filing application. So this is the program which we have started somewhere in 2013, but majorly we operationalize in 2016. Since then, we are funding these startups for patent filing. And if we talk about next 5-year plan in terms of how biotech startups will grow in terms of IP filing, in terms of the research. So now, as you might be aware, like deep science, we are talking about the deep science or deep science biotech related technologies and projects. So slowly and slowly, when we are moving towards this, so of course we have different programs where we will fund those startups for the deep biotech, and the patent or the IP protection definitely is going to be very crucial for them. So if they don't protect, that will involve a lot of complexity in terms of the IP protection, IP filing, because when you talk about the different components of the deep science, then you have to have access of those components also. So that will not only IP filing, but in terms of having access to the different components from the different organizations. It could be from the Indian organizations as well as from the international organization. So considering those aspects, and you draft your patent application, you protect those innovations by any form of the IP, then of course. This is going to be very, very crucial for the next 5 years, because we are moving from now what translational science, of course, that was also helpful for us, still helpful for us. But when we are moving towards the deep tech science, then yeah, IP definitely plays a crucial role. And also, if you are aware of DBT Birec announced the biomanufacturing thing,
yes,
where we are talking about the deep science involving the different, we have announced different calls in different themes, including the synthetic biology, climate resilient crops, bio AI hubs, and biomanufacturing of the critical enzymes. So different components are there. And if you see in each component, different, parts and plugs are needed. They might already be IP protected, then you have to have access from those organizations. Or if you are creating on your own, definitely you would like to have a IP protection on that. So that is one example where IP definitely will play a critical role in the next 5 years.
Thank you, ma'am. Biomanufacturing hub is one of the key in deep science in biotech's arena. And I am sure this is going to, regionally as well as nationally pitch us in very competitive landscape, both in knowledge economy as well as innovation-driven startups and further shoot-offs from our major organizations, basically. So thank you very much for putting that insight, ma'am. Coming to you, Nirvashini, ma'am. With perspective to South African innovation ecosystem and your expertise in it, India is also looking at cross collaborations wherein we can learn from use case scenario from different countries and try to see what improvised pathways we can build in this knowledge driven economy and ecosystem. So how do you see that and your take on how we can start thinking about cross collaboration in IP and tech transfer space, and what early challenges you see wherein organization like BCKIC or PIRAC can discuss, deliberate, and try to see a pathway wherein we can quickly cross collaborate as well. Let's say for a startup from India and go and deploy in South Africa at an easier way possible, or a startup from South Africa coming to leverage on the Indian innovation ecosystem, how we can bridge this gap.
So I don't think my answer is going to be a simple one, Sudhir, because most ecosystems are not actually performing as ecosystems, innovation ecosystems, so to speak, because of the lack of the understanding of the connectedness, the interconnectedness inside the ecosystem, but the connectedness between other ecosystems. So that's why I say it's not a simplistic answer. You have numerous organizations that will work in each ecosystem, but often, and we see this very strongly in the South African space, they tend to be working in their silos, right? So as a result, you have a lot of really good opportunities in these so-called ecosystems, but because they're not connected, you don't get the level of impact that you actually seek to achieve. So often, if you're using the correct rationale and spirit of innovation and innovation management, it asks for a connected mindset from day one till the time you have, whether it's a startup, whether it's a technology, whatever it may be, in the market and performing as you would expect it to do. So to do that, you have to have organizations that are basically almost like in a relay race where they hand the baton on to each other. But what we do see is organizations are doing the same thing. They are mandated to do different things, but they are doing the same things. So within an innovation pipeline, you have several organizations that tend to be funding either at the very early stage, or all of them are funding type awareness type things, or that sort of thing. Whereas you should have, for instance, an organization that starts to help, whether it's, like I said, researchers, technologists, startups, firstly understand, let's just say why IP is important. Then move the startup into the next organization that says, this is how we fund your work and related to the IP. This is how we see the value from your IP, so on and so forth. So basically looking at, let's just say, the whole TRL space, the whole innovation pipeline, but taking a sort of, like I said, a relay approach to it to connect up the system. So when you're looking at collaboration as well, you would need to take that sort of a strategic mindset. Who in that ecosystem, in the other country that you're looking at talking to, is actually taking a structured approach to innovation, right? Is it just that I'm looking to finalize a KPI? So do I just want so many patents that are filed? Because a patent filed means nothing if it's just a KPI. You can tick the box and you're done. You're basically wasting money for another 20 years. But if you're looking at organizations that actually see the value, the investment value, have a long-term focus for that patent, intend to exploit it, have a multidisciplinary approach as well, because we know we're taking any technologies to market, you have to have a legal approach, a market approach, a research approach, a business approach. In the IP space, and I think all of us know this, although some of us may be in very specialized spaces like the IP attorneys and so on, but I think we all have a very firm grounding and understanding that it is one of the most multidisciplinary spaces to play in, because you cannot get to the end point if you just, for instance, focusing on getting a patent and you haven't looked at how that patent is responding to what the market needs. If you're not tracking the market from day one, because markets change overnight as well. So what I'm basically saying is that, yes, there's always opportunity for collaboration, and I'm very much a proponent of collaboration. But as you would with your startup and the research you would need to do for your IP and your market, you should also do very robust research in terms of who your collaboration partners are, because ultimately you could then hamstring your startup, hamstring the collaboration by picking the wrong partner who's just available versus who's going to strategically help you open up new markets, build your IP, build your investment value, bring in additional investors, and so on and so forth. So there are numerous opportunities in the South African space, as I believe in the Indian space. But I think our role, the people in this room, is to start playing a greater role in terms of helping startups, helping researchers connect those strategic dots, bring in strategic players that are genuinely looking for collaboration and an actual functioning ecosystem, rather than kind of, like sort of quick fixes that are not really quick fixes at the end.
Thank you. Thank you for putting that precisely, that how entire innovation ecosystem should behave and take the best practices forward. And indeed, that should be the spirit in terms of how we cross collaborate and see the right commercial approach to and techno market commercial legality of the entire ecosystem. So thank you very much. Pawan sir, to you again, being from research and academia, policy at ecosystem level and how that policy level policy making does or create or disturbs the entire ecosystem. What better ways would you suggest for IP commercialization from our pioneering institutions, especially all the research institutions what we have, and leveraging that for societal developments, because these are our open IP or intellectual properties.
No, if you can please repeat, because there was some technical issue. I could not follow the full query.
So basically, for research institutions, we have a lot of innovation which has already happened. We are sitting at a pile of innovation and intellectual property in all these institutions. But when it comes to commercial or societal implementation of these technologies, we lag. Is it the policy level deficit which is creating that, or do you suggest an alternate how we can quicken this process?
Yes. To certain extent, it is policy level also, because our structures are made in a manner that the recruitment, assessment, and all other activities related to the professional development goes with reference to publications and their impact factor. Though there are good number of inventions, good number of IPs, but hardly people are looking into their exploitation, because majorly they will be assessed with respect to publications, projects, and the impact factor of publications. Still, even though we talk about innovation and IP, but in practical sense, this is what is happening. With respect to CSR, compared to other organizations, CSR, I feel, is following a more stringent way. We now started looking into the projects, ECF we call, external fund cash flow, and then technology development, IP, and IP commercialization. And under these aspects, mapping of researchers is happening. Of course, in coming years, it will become even more organized. And from policy level, yes, I believe there should be a strong change in the guidelines. Once you are a beginner at your career, yes, you need to have a flexibility to perform your activity with respect to publications or basic research, whichever you wish. But after you gain certain years of experience, it should become a mandatory activity for you to contribute towards technology, innovations, and IP. Unless we bring into this practice, I think seeing a big change is not that easy. Likewise, NIRF, NAC, they all brought into their questionnaires about the IP, patents, different patent filing, you get 10 marks, patent published, 12 marks, patent granted, 20 marks. So now what reverse strategy people started using is, getting a granted patent is very difficult because you need to do a actual invention. Rather than having 10 granted patents, better have 50 filed patents where your score will be much more than the granted ones. So that is where some people, now I keep getting so many WhatsApp messages. First inventor 10,000, within 2 months you'll get the patent. Second inventor 8,000, and slots are filling very fast. Be fast. And if you go up to 2 inventors from the same institute, 10% discount. So now, where are we going? Right or not? And we have also requested, we had a chance to interact with our Science and Technology Minister, and we have suggested that there should be a mandatory curriculum on innovation and IPR from school syllabus itself. Now, though by national IPR policy, it has been suggested for all the higher educational institutions to have a course on IPR, to have IPR cells, but hardly few people are implementing, many others are not implementing. But this practice and this course has to be taught from the school level onwards, because we study all subjects from the school. But when it comes to IP and innovation, once you become a startup, once you become an entrepreneur, once you become a faculty, people start expecting from you. Neither we were trained nor we were nurtured in this direction. And we have also requested, like recently government has brought up one nation, one subscription. We have requested them to include some patent databases in that activity. Because from last year onwards at CSR IMMT, we started subscribing a paid database, a few paid databases. And along with the free databases, we have also kept this paid database open for anyone at our library. We titled it as Patent Search Kiosk. Whoever visits IMMT at free of cost, they can go to our library and use this facility. Because like Vinita was suggesting, patent searching is more important. Yes. Because 80% of literature survey or background survey for our research is limited to scientific publications only. Earlier, it used to be fully scientific publications, but now at least 20% of the researchers are also looking towards searching in patents. 80% still not looking. This is a practical experience that we are feeling in the ground level.
So we have seen good strides, but further, as you said, early awareness at school level, and BCKIC Foundation is spearheading that as well. We started interacting with all the ATLs across Odisha and started igniting that at very early stage in technical education and converging it with the IP, slight aspect of IP as well during the last year. And we have seen some good positives in that arena as well. Thank you, Pawan sir. Sudha ma'am, to you, with compliance and IP laws, everything, we see a lot of awareness getting created. How do you, suggest for our startups or early innovators to have a compliance with IP laws and at the same time maintaining a creative freedom and community spirit to the platform? Because the balance also is very much important for our innovation ecosystem. So your take on that, ma'am, please.
Yes. So I think when it comes to compliance, the type of compliance that is required and the applicable laws governing that particular industry or that particular sector in which a startup is engaged in will vary as per the applicable laws. Right. So let us say that if it is a startup which is engaged in content creation or in assisting creators, then in such cases, this startup can focus a lot on drafting good agreements, drafting reasonable agreements, which give importance to ownership clauses in the same, wherein it should be very clearly demarcated that whatever a creator is creating, is it just a work for hire arrangement, or is the IP that is generated eventually is jointly owned. Then monetization models should also be very clearly outlined in all such agreements. All the startups, I mean, it is a mandate as per the intermediary guidelines and all that you need to have well drafted and in simple terms clearly highlighted on the websites, the privacy policy and terms of use, wherein any user can go to these terms of use and understand what is expected of a particular user, what are the responsibilities of a user. Then when it comes to privacy policy, it should also clearly highlight that what is the data that is being collected from a user. All these are compliance related aspects that need to be taken care of by any organization. It's not just limited to startups. And with digitalization of IP, there has been a lot of spike in online infringements now. So one, along with external compliance, I think in-house legal teams should also, and organizations should also focus a lot more on internal assessment. They can try building internal tools, have proper grievance officers appointed under the applicable laws to for which they can have a proper mechanism in place, that what is the process to be followed when you receive a copyright complaint, what is the process to be followed when an organization receives a cease and desist notice, right? Then AI based monitoring tools, automated takedown services, all of these can be internally taken care of to cater to the larger need and a larger compliance required by law. So I think Delhi High Court and Mumbai High Court are actually pioneering in grants of lot of injunctions which help content creators, which help founders to protect their IP, say dynamic injunctions against rogue streaming sites. So overall, I think having proper agreements in place and making sure that the companies or organizations' terms and conditions, privacy policies in accordance with the law will help structuring the overall IP requirements of the company. I think this is the bare minimum and basic boundary that every company can look for to creating. Yeah.
Thank you, ma'am. Thanks a lot for putting that spotlight onto the compliance aspect of it and how well we should follow all these, keeping the creative freedom intact as well. Coming to you, Aurobindo sir, dispute is one major segment in IP and intellectual properties of all types. Though India has been early, but the issues are coming up one by one. We see the questions coming up or disputes coming up here and there in some of the arenas and some of the sectors. So how do you counsel, being a consulting body, how do you counsel with dealing all these IP disputes, infringement in an international perspective as well as an Indian perspective? It can be a smaller trademark dispute wherein a first report has come that you are infringing on. And how do you, suggest our startups or early innovators to, follow the compliance in that aspect with perspective to disputes, basically?
Yes. So when the dispute arises, our entrepreneurs as well as founders are more active and more thinking about IP. At that point of time, if the first question is whether you have protected any IP, around, I would say 60% of them say that, okay, we have not protected the right form of IP or the right kind of IP. Let's say if it is a trademark, they'll say that their hotel name has been copied. There are phishing websites that people create for them, but at the same point of time, their trademark has not been filed yet. Okay. So that's where the first consulting start is. Again, go back one step back, try to protect their IP also. Rather than writing a straight cease and desist notice where it can be a little questionable. At the same point of time, when it comes to international mode of enforcing your IP, if it is online, I divide the question into two parts. One is an online mode, and if the infringement is in online, let's say if someone is selling the same product as you are selling on Amazon India and Amazon US, so how you need to enforce. So that is up to a large extent has been resolved in terms of the big players or the big websites have their own mechanism which do the DMCA takedown notice or the takedown notice and the desist online notices which has been sent, and they really take it down within a few days. So up to the larger extent in terms of the bigger websites in place, those who have a lot more traffic and they are particularly in US, these online enforcement are a little easy nowadays. When it comes to enforcement in terms of your patent is in India and you want an enforcement in US where you don't have yet, but still there is an infringement. and you have missed the timeline to file the patent in US. So that's a complex thing to enforce your right, even if there is infringement happening. So at the same point of time, you need to see how this tech transfer happened, whether someone has brought, let's say, purchase something and brought it to US and do something in terms of to get a new patent out of it, or maybe using the same technology as yours. In Bhubaneswar especially, we have been into a few of the courts where just to establish that there's a copyright infringement in the court takes so much challenge, because the judges and the system is not fully developed in terms of understanding, okay, this is an infringement in terms of copyright when it comes to software infringement in office environment. If it is on the face of it, they are, let's say, if it is a copyright infringement on whether when you have a physical copyright which has been copied by someone else, then that is much more easier. But when it comes to someone, let's say, in your someone of your employee copy another of more know-hows and let's say the copyrights of your organization and try to go to the same clients that you have and try to give them the service. Just to establish that in a court takes time. And obviously we have done that also. We have got injunctions in terms of both on a preliminary injunctions also. But at the same point of time, enforcement in IP, first, we are not protected. And second is the law takes its own course of time. So it more time to enforce. So better that you protect your IP at the first hand, so that the kind of enforcement when we do, whether it is online or maybe on the courts, it's much more easier.
Thank you, sir. With this, we try to conclude and see that different spheres of IP and innovation ecosystem, what India and internationally, which we could leverage on, and it would be a very good interface for all our startups, early innovators, colleagues who have joined today to understand different facets and different paradigms of innovation ecosystem which we are playing in. There was one question in the group, Aurobindo sir, for a quick this thing which you can help me with, requesting for sharing the IP registration process for an innovative product. This in itself is the drafting and everything, which we will take it further with the individual. Registration costing parameter, that is one aspect which I would like you to quickly, summarize on, because that was a question put in our chat. So I just picked up.
A patent you are asking?
Yes, sir. Yes, sir. Registration process or patent, basically, that's what they have written. Registration costing parameters, basically.
So
the
for the patent,
one.
individual, it's, if it is a patent, if it is individual, the government fees is very, very less as compared to the entire world, I would say. Just like the 1,500-1,600 rupees, you are able to file a patent application for month. That's like the best cost effective application that I have seen around the world. When it comes to lawyers coming into picture, their cost, the cost that you have to bear, it differs from, you would say, a minimum of, you should have a budget of around 30,000 to 1 lakh rupees to go through a patent in India, particularly. And then if you want to go outside India, then it goes on. It's add on more information. But when it comes to the government fee, whether it is for an individual and for startups, it's pretty less as compared to the outside.
Thank you very much. Now I would request our scientific communication lead, Dr. Aanchal, to summarize on and thank our esteemed guests and the audience. Aanchal ji, to you, please.
Thank you so much. Before I conclude, Sudhirji, if I have a permission, just for the student participants who are there today, we got the gist of it. We are no IP experts, but still listening to you all, I think we understood a lot. When should a student who is, focusing on startups, building up startups, should approach or should go for an IP exit, because it's still not there in the curriculums. So till it takes the time for it to come in the curriculums of schools and colleges, what would be the best time, other than reaching to BCKIC? How could they approach someone who they feel would guide them through at their school and colleges level? That's it. A small answer, and then we will conclude it. From any of our experts, please.
So if you'd like to, I can take this question up. So when it comes to schools, it's very important that I feel their brain is working the best.
Yes.
And they have nothing to lose. They are so open, they can think out of the box, right? So that's where the innovation happens, and that's where they should have tools to check. And we are building up tools also to help out to our clients and entrepreneurs who are into, let's say, into trademark, but something on patent also we'll build this year, where they can easily check with the help of AI coming into picture in terms of the legal advisory or the legal search. In terms of that part, at least, we want to leverage AI, and we want to really reduce the cost of getting the trademark searches down, getting the patent searches down to almost nil, where the innovators can instantly search and get a result. And when they go for the next step, obviously experts like us can come into picture, and we can have some commercials at that point of time. But when it comes to research, it should be free. It should be completely, since the intelligence is there with AI, which we also have. So we want to leverage that. Obviously, IP tool in terms of IP Sathi is coming up, which is the IP India website. You can go through, you can do the research. When it comes to simple things, let's say if it is a patent or an idea, you can go to Google Patent or lens.org and go for a simple patent search to know what are the documents available, and then take it off from there.
Thank you so much. I think that was a answer I was looking for, and all the students and the college students who are there in the audience, I think they would have understood what they should go through. So thank you again. So now I would conclude our session. So thank you so much. First of all our experts, Dr. Vinita, Dr. Pavan, Dr. Nivashrini, Mr. Arvinder, and Ms. Sudha, thank you so much for coming and giving us your valuable inputs and obviously your precious time. So thank you once again. And thanks, Sudhir, for asking such brilliant questions, because those are the most important things for getting answers from the experts. Otherwise, a 1-hour session is not enough for an IP. And that's why we keep on having it, not just on this day, but all through the year. So thank you once again, and thank you the whole team of BCKIC for having this. So I think in this whole session, what I understood and which everyone would have got the gist is about, first is to start locating, or the importance of start locating the patents, where to look for, when to look for, and the importance of having an early registration rather than, as said by all our experts, sitting on it and after years realizing that they should have been protected. And then obviously awareness about the copyright laws and how can we use these IP for our commercial benefit. Because if we don't do that, then the motivation of doing it also goes down for everyone. And then obviously treating IP as an intangible source, as said by experts. And I would again like to add that we also understood that the IP can be used strategically, like when we think of collaboration, just not do collaboration randomly, but use it strategically. Think about the collaborators who can be actually of use, and we can move ahead with them. And especially thanks to BIRAC, I would say, for coming up with such programs, because as we said, on policy level, government can make the biggest changes. So if the policies are right, the programs are right, obviously all the startups and innovators would know what to do and where to go about. So I think if I'm missing anything, Sudhir, we can add on. But obviously and specifically, I think I missed a point is of having an international collaboration, learning from the international systems. If something is, we have a major gap in our Indian system, as I realized. So we should keep learning, we should keep our system open and not get stringent about some of the laws and keep changing them, requesting the policy makers to to change it so that everyone can make use of it. So thank you once again. I would thanks all our experts, and a big thanks to the participants who have come on a Saturday. I know it's a very interesting session, but then they have come on a Saturday listening to us. So happy World IP Day, I would say. And thank you once again. Sudhir, if there is anything left, you can
That's it.
say.
Thanks a ton, all the panelists, all the audience for having the patience, and a very warm wishes on the World Intellectual Property Day today. With this, we will conclude this session. Thank you once and all to everyone. Thank you.
Thank you.
Thank you.
Thank you all. Thank you very much.
Bye.
Thank you all.
Thank you very much, sir. Thank you, everyone.
Thanks. Bye, everyone.
Bye-bye. Bye-bye.